Army veteran Adam Smith Connor has been fined and is said to be challenging that fine for praying silently in his head, ostensibly in breach of a public spaces protection order. I've spoken about public space protection orders a lot in the past, how they work, how they come about, how they need to be challenged if you don't want to be caught by one of these. One of the references in relation to drones, because some councils have decided to just ban drones in the entirety of the area. The legality of which is somewhat questionable, because if they create one of these public space protection orders which restricts certain types of things which there is already a law that covers, then they shouldn't have been made in the first place. But any such challenge should be done so within a very strict time frame, otherwise you can't challenge it until it expires, and they run for a certain amount of time. So, as I said, veteran Smith Connor has been fined for praying silently in his head. He's reported to have been praying near an abortion centre because he lost his son to an abortion some 20 years ago, and he said that it came back to grieve him some years later. This, all of which follows my previous video where Isabel Vaughan Spruce is also due to appear in court this month coming, actually in February, for exactly the same thing. She said that she was praying silently in her head. Now, of course, there's two sides to this debate, one of which is that MPs have voted to allow these public space protection orders and to create these exclusion zones around abortion clinics to prevent people from being harassed and otherwise intimidated. But one might question whether someone is really intimidated and harassed by somebody else silently praying in their head. That, in my view, is a very subjective analysis and conclusion to draw, and is one very difficult to generalise so much that you can create a law that would literally criminalise this sort of activity in and around certain areas. But there is also, in my view, a much deeper issue at play here, and that is whether or not we are curtailing free speech and religious beliefs. Focusing on the religious beliefs aspect for a moment, leaving aside freedom of speech, which is a qualified right, freedom of expression can be curtailed if the government deems that it's illegitimately necessary. However, Article 9 of the European Convention on Human Rights protects your right to hold both religious and non-religious beliefs. More importantly is that this is an absolute right, meaning it cannot be interfered with by the state. Now, your manifestation of said beliefs is another matter. So, for example, if you took your religious beliefs to the extreme and you wanted to carry out extreme behaviour, then of course that is going to be something that the state doesn't permit, and so your exhibition of those beliefs and your expression of those beliefs that you hold is curtailed, quite rightly, by the state. However, surely it must be where that line is that we draw between the absolute right under Article 9 to hold these religious beliefs as against the freedom to express and manifest those beliefs. And there has been case law, as it happens, on this very issue. For example, we can look to one case which was Grostelev against Russia. In this case, the applicant was a practicing Muslim and detained in a penal colony in a region in Russia, who complained about a violation of religious beliefs after being reprimanded for praying during the prison's obligatory nighttime sleeping period. In this case, the court held that there had been a violation of Article 9 of the Convention, finding that the interference with the applicant's freedom of religion, namely the imposition of a disciplinary punishment, could not be regarded as having been necessary in a democratic society. The court noted, in particular, that the only reason for disciplining the applicant had been the formal incompatibility of his actions with the prison schedule and the authorities' attempt to ensure full and unconditional compliance with that schedule of every prisoner. So, of course, there is a distinct difference here in that the main reason was that it clashed with nighttime sleeping, and this applicant wanted to express and practice that religion during that time, and so the court found that there had been a violation. Comparing with the public space protection orders, however, there is an argument to be had that it is not simply complying with schedules and other administrative burdens. Rather, the very existence of these orders has been to protect people that go to these areas from said harassment and intimidation. However, then that begs the following question as to whether or not it really could be concluded that someone is going to be harassed or intimidated because of somebody else in that vicinity conducting silent prayer. Certain types of protests, vocal, visual, and all of that sort of stuff, quite possibly could cross that threshold and become harassment and intimidation. One might therefore argue that simply somebody standing there praying may be argued to be intimidation and harassment, but I suspect that a lot of people will believe that that is not the case, and that that is a little bit too far to cross that threshold to restrict somebody from manifesting their beliefs in silent prayer. After all, no words being spoken and only silent prayer going on inside their head. For one thing, unless they outright admit that there is a prayer to that effect, then there could be no proof. But I believe in each of these cases that it's been admitted that there was prayer silently in their head, and therefore they've certainly this one chap has been fined and the other lady is due to appear in court in February. But nonetheless, this just goes to show once more that you can be investigated, arrested, charged, prosecuted, fined for something that you haven't even said, something that is only going on inside your own head in support of your own religious beliefs, which once again, per Article 9, is an absolute right to hold those beliefs. It's only the manifestation and the expression of those beliefs that is somewhat curtailed by the state. As I said, the most obvious example being the extremist expression and manifestation of those beliefs that is curtailed. But this, of course, at least on the very face of it, appears to be right at the other end of the spectrum, where there is no actual action going on at all, save for standing within that exclusion zone. So I do believe that this is going to come to a fairly heated debate, and it's going to have to be something, in my view, that Parliament takes a stance on one way or another. There must, again, in my view, at some stage be a clarification of what is permissible, what is lawful, and I suspect if another area is destined for one of these public space protection orders and somebody challenges it, probably by way of judicial review, citing probably some of the case law that I've talked about in this video, although that is by no means going to be exhaustive. I found that case within 2 minutes of research for this video, and there's bound to be many more of them where somebody's rights to hold and express religious beliefs have been curtailed unlawfully. So I suspect that one of these cases is going to end up in a judicial review, and the judge is going to look at things such as Wednesbury reasonableness. In other words, whether the decision, a public law decision made by a public body, was perhaps so unreasonable that nobody ought to have made that decision. That is potentially one outcome of a judicial review if somebody does challenge one of these public space protection orders before it actually becomes in force. And as I say, there are very strict timeframes within which to do that. And just as a brief overview, although I've covered this in many other videos before, these restrictions can be imposed under the Antisocial Behaviour Crime and Policing Act of 2014, and if one were to challenge a local authority's decision to introduce a public space protection order under this, Section 66 of the Act creates a very specific statutory appeal route which must be followed only by interested persons, and this challenge must be made within 6 weeks. Interestingly, and rather strangely enough, the Act explicitly prohibits an interested person from challenging a PSPO, Public Space Protection Order, by any other route than this Section 66 procedure appeal within the 6 weeks time frame. However, the standard judicial review to which I've referred is not removed for those who do not have the interested person status, which I do find a little bit odd, but I suppose what it's trying to do is streamline the process for those that do have an interest, to force them into this appeal route, to ideally streamline the administrative burden of all of this, to come to a conclusion on those appeals much more quickly. One such challenge, I believe the first, was Summers and Richmond upon Thames of LBC in 2018. This was a case supported by the Kennel Club. Miss Summers challenged certain aspects of a public space protection order for a place in Richmond. Firstly, it was on the limit of the maximum number of dogs that could be walked by one person. which is of course an issue for those that carry out the activity of dog walking. I regularly see people walking 6 or 7 dogs around. And secondly, a prohibition on dogs not being under proper control, causing annoyance or causing damage. She argued that the exemptions for assistance dogs were too restrictive and in breach of the Equality Act of 2010. Which of course would be anything that unfairly discriminates against somebody holding a protected characteristic. In that case, clearly any kind of disability whatsoever that required the services of an assistance dog. If this was restrictive in such a way that it is discriminatory against somebody holding such a protected characteristic, that would deemed to be unfair under the Equality Act of 2010. The first case was to decide on the legality of this PSPO, and the judge was required to interpret Section 66 and to establish the level of the review that had to be applied. Ultimately, the bottom line is Miss Summers was partly successful in the challenge. The judge ruled that the annoyance provision added nothing to the provision of keeping a dog under control and that there was insufficient evidence to demonstrate the need for a prohibition on causing damage. However, the bulk of that PSPO remained intact. So it will be very interesting indeed to see whether or not there is firstly a Section 66 challenge on any kind of PSPO that is proffered by a local authority in similar circumstances to this abortion clinic. And secondly, I'd be very interested to see whether there's any judicial review launched by a non-interested party, because that route is still available for non-interested parties, to see whether or not such a decision is considered by a judge to be so unreasonable that they ought not to have made it. But as I say, there's going to be competing arguments. It's probably going to be quite a fierce argument, but I will be very interested to see the results of such arguments as they pan out. So leave me your thoughts and comments in the box below. Do you think it's perfectly reasonable that these space protection orders restrict silent prayer in such areas, or do you think that someone should still be able to have the freedom to do that? Whilst you think about that, I would suggest thinking outside the box a little bit. Instead of just being one person, imagine that there is a crowd of 100 people all gathered in some kind of joint prayer. Might that amount to intimidation and harassment? That's certainly more likely than a single person. Just something for you to think about while you leave me your thoughts and comments in the box below. And please remember to smash that like button and subscribe. As one of the very few barristers here on YouTube, I do enjoy giving you my legal views on various cases and bringing you news as and when I come across it. And in the meantime, thank you for watching.